Kevin, you can at least hear me. Is that right?
Oh, loud and clear. Can you hear me?
Yeah, perfect. All right,
okay, yeah.
Okay. Baruch atah Adonai Eloheinu melech haolam, asher kedishanu b'mitzvot v'tzivanu l'asuk b'divrei Torah. Varivna Adonai Eloheinu divrei Toracha b'filu f'yamcha beit Yisrael. V'niyeh anachnu v'tzetzenu v'tzetzemcha beit Yisrael kulanu yodea shemecha v'lomdei Toratecha lishma Baruch atah Adonai hamlomei Torah le'amo Yisrael.
Amen.
Baruch atah Adonai Eloheinu melech haolam asher b'chabanu mikol hamim v'natan lanu Torato Baruch atah Adonai noten Torah.
Amen.
Amen.
All right, we're going to start off with the Mishnah Brura. We're going to start very quickly, okay? I know everybody's got a day to go to, including myself. So this is by Rabbi Daniel Brody, Rabbi Gary Brody's brother. We were discussing the laws on the Mishnah Brura and the Shulchan Aruch. Okay, we're on section 181 of the Mishnah Brura and the Shulchan Aruch. And what we're going to discuss is the issue of drying hands, women, and other leniencies of Mayim Achronim. So with regards to drying hands, it's good to dry one's hands from Mayim Achronim. However, the Mayim Achronim is certainly halachically valid, whether you dried your hands or not. The reason why I'm saying it's certainly good is because the towel is brought around and it's just considered more derech eretz. But halachically, it stands whether your hands are wet or not. Now, in terms of the amount of water, unlike washing before bread, you don't need a revi'i of water. You know, with the revi'i, you basically need a vassing jug. As far as Mayim Achronim is concerned, we learned that you need as much water to clean one's hands and reach the minimum part of the hands mentioned before. What we said is minimum up to the knuckle, and it should be the whole hand if preferable, but the halachic requirement is up to the knuckle. Some say the knuckle is here, and others say some say it's up to here, but the major halachic opinion is up to the end of the knuckle, if there's enough water up to the end of the hand. People that just wash their fingers are halachically not fulfilling their obligations. So basically, the tiny jugs that you buy at the Judaica store is insufficient. You know these little ones where you touch your fingernail? It doesn't work. And I've gone to very choshev people that use that. It's not enough. You know, when I go in Israel to some Haredi families, they have a proper vassing jug, especially if you have to do it up until your knuckles. Some say the base knuckles, some say the main palm knuckles, etc., etc. Now, in terms of leniencies, these are the rules for Mayim Achronim, which are less strict than washing before bread. Just let me put off my phone, guys. Okay, my phone is off. Okay, you can use other liquids such as oil, milk, or juice for Mayim Achronim. That to me is a new one. I didn't know that. It's not just for washing your hands. So obviously for washing your hands, it's purely water, Mayim Achronim, oil, milk, or juice, because the rule there was to clean it from dirty fluids, as well as sodium bromide, the sort of preservation used, the salt they used in Sodom in the temple. Okay, even if you have it's been used for some work or changed color, or an animal wouldn't drink it, you can use it. Okay, so apparently then it's not fulfilling the obligation of cleaning the hands, but it's certainly taking off that Sodom salt. Okay, so even if the water looks a little bit dodgy, you can use it. You need not specifically pour over, which is why a tap or dripping is fine. Do you remember what we learned when we were vassing, that you have to use your own force to pour? In this case, if you use a dripping tap, it's sufficient. Do you remember that, guys? When you're vassing, that it wasn't sufficient to be able to hold your hand under a tap. So here with Mayim Achronim, you don't need your own force to pour. Okay? And then just one thing and then we're done, don't worry. There's no issue of chatzitza. What's chatzitza? Things on the hands that would block the water from coming on. It's not an issue. So like when somebody goes into a mikveh, you have to make sure there's no rings on the finger. Does that make sense with a woman? That if a woman's vasting for benching, she has to take her rings off. Even not benching, sorry, for vasting for benching. But for my machronim, she doesn't. So that's also leniency. All right, so woman, the general custom of Klal Yisrael is that women don't do my machronim, as it's treated as a stringency that they don't have to take on, but they may certainly do so as they wish. Rav Shlomo Zalman Auerbach used to say that women can do my machronim. No problem. All right, let's go ahead with the daf. And I just wanted to put a case, obviously Arthur isn't there, but I just wanted to give a 2-minute summary, and this is going to help you. So what we learned yesterday in 1582 is the Gemara quoted that both the damaged party and the damager are involved in the payment. And the question comes up, what do you mean the damaged party is involved with payment? Surely the person that does the damage, the damager, is entitled to pay the injured party. How does the damaged or injured party involved in their own payment? So we said that we learned it from 2 bases, and we're going to go through it now. So what it does is it introduces the opinion of Rav Papa. Now, guys, did Rav Papa, in your opinion, say that, what did he say? Did he say it was a penalty or compensation? I'm testing you guys.
Penalty.
No, Rav Papa is the other one. No, he says compensation.
Yes, Rav Papa said compensation. Yes. Okay. And who said the opinion that it was a penalty?
The other guy.
Yeah, who's the other guy? Okay?
Definitely the other guy. I've got it right. My answer is correct. You can't fault my answer.
Yeah, the other guy could be anything. So who is it? Guys, do you know?
I'm not good with names, though.
Yeah. All right. So I'll put you guys out of the misery. So Rav Papa said it's a compensation payment. Rav Huna, the son of Rav Yehoshua, said it's a penalty payment. Okay? So this is what was basically said, and I'll say it. Gav, let me just have a chance to go through the share, please.
No, one crap, I apologize.
Please, but so basically, because I want to go through this really quickly. All of you have got a day to get on with. So Rav Papa was saying it's a compensation payment. And why? He says because oxes are usually safe. So if oxes are usually safe, then if they damage, then basically you should pay for all the you should pay for the payment, because if your ox is safe and it's done damage, in the case of Tam, it wasn't forewarned, and an ox is generally safe, and therefore Hashem is merciful, and he only makes you pay half the compensation. Why half the compensation? Because an ox is generally docile. It's known to be as a safe animal. And because it's a safe animal, you haven't done anything wrong, and therefore it's a first-time offense, and you pay half the compensation. Rav Huna, the son of Rav Yehoshua, said it's a penalty payment, and the ox is not safe, and you should have looked after it more carefully. So therefore, you clapped with a penalty. So let's just understand, which is going to come up now in the new material, what classifies a penalty. So we've learned this a couple of ways. We learned that a penalty, when we learned of, for example, the ox and the sheep, that the penalty is more than the compensatory amount in many cases. In other words, compensation is what's fair. I cost you 100 zuz worth of damage. I pay 100 zuz because I'm recompensating you for your loss. When it's a penalty, it's when I have to pay more than that in order to deter me from making a mistake again. So, for example, when Mayor Giuliani put in New York a penalty payment for litter, I don't know if you remember, New York was a sty. It was filthy. It had graffiti. And the minute there were heavy penalties for spraying graffiti or leaving your trash that superseded the value of the damage, people were vigilant not to create damage because they didn't want to be clapped with a penalty. So a penalty means that I don't really owe you the money. So what Rav Huna, the son of Yeshua, said is that the ox is generally, even though it's generally in a safe space, it's still my obligation to watch it. And therefore, if I'm negligent, you get a penalty. And his view is the reason that you only get a penalty of half the amount and not compensation is because he's not interested in the restitution of the person that was damaged, because that person is not entitled to anything. In other words, this is to punish the damager for not being cautious. And he said that there is even a penalty when the ox is tame, when the ox is tam. And the reason why there's a penalty is you don't want it to get to the stage of a muad where you're still keeping the animal if it's a habitual gora. So what we were saying is how does this relate to the damaged party also make payment? So we're saying if you want to rule according to Rav Papa that it's compensatory in nature, then basically if I'm paying you tam, which is for a tame animal, half the payment I owe you, it means that the injured party is taking a hit and a loss of 50%. Because in that compensation, they're entitled to, for example, 100 zuz, and they're only getting 50 zuz worth of their damage back. So therefore, the injured party is also contributing to the payment. Does that make sense according to Rav Papa? It makes sense. Now, we have a bit of a problem because according to Rav Huna, the son of Yeshua, it doesn't make as much sense. So we're going to say, listen, in what way does the injured party contribute to the payment? Because if you want to say it's a penalty payment, you're going to say that the injured party is not entitled to anything. The penalty payment is there to clap the damager for not being vigilant in watching his ox properly. That's all it's there for. Is to try and teach the person a lesson to be more animal. But because it's a tame animal, he's not entitled to anything, the injured party. It was a random accident. But it was just there to ensure that the person, even if the animal is tame, next time looks after the animal as though it was a muad and although it was an aggressive animal. So it's there purely for the aggressor owner's ox. Does that make sense? To get him to be careful. So therefore we say that because the injured party here got 50% of something he wasn't entitled to get. It's not that he got 50% of something he wasn't. He's not entitled to that penalty payment. It was a windfall for him. He's not entitled to anything. Again, the ox was tame. The ox never had a history. The owner wasn't warned. In other words, it was a random accident, and it just so happened that the penalty that was charged to the damager for next time being more awake goes entirely to the injured party. And he wasn't legally entitled to anything, and therefore he should be happy in a certain sense, because he could have got nothing. So we're saying in what case then is the injured party having to contribute to the payment? Because it's not like you view it as compensation where he takes a 50% hit. He hasn't taken a hit. The money's a windfall. Halachically, he wasn't entitled to anything. So we're saying that must be something else. And it was a point Michael brought yesterday where he was talking about the depreciation of the carcass. So what it means to say is as follows, is that point when that person's the injured party's animal dies, there is going to be deterioration of the carcass where it starts to rot at that point. It starts to lose value every day until the case is heard in court and it's measured and it's weighed, etc. In that particular case, okay, there is deterioration of the carcass. And in that way, the injured party also pays. In other words, he gained the benefit of the penalty payment, which, by the way, could have gone to the court and not the injured party. So that was a windfall because he wasn't entitled to anything. Again, the animal that attacked him was tame. It was random. But he's now suffering the loss and contributing to that loss out of the injured party or the damaged parties by having to absorb the cost of the depreciation of the carcass. Okay. So that's what we're learning. Now, this is the chiddush that comes up, guys. And this is something that we touched on in 15a2. And what did we say? Is that basically is that we were saying, listen, we can understand this. Why did we need this to be proved for the depreciation of the carcass, Michael?
Sorry, just say it again. Why didn't?
Okay, I can see when people drift. That's why I put them on the spot.
Yeah.
So what I'm saying is we learned a case of depreciation of the carcass. Where was it? What was it related to?
The second case.
No. We learned it before in the duff. Where was it, or in the context of depreciation of the carcass?
In the pit.
Yes.
Yeah.
Yes.
The pit story. Yes, correct.
That's absolutely correct. So, was the ox then? Now, I'll tell you where it was. It was in 10b. We learned it in 10b. I don't know if you remember that.
Yeah.
Okay, well, I didn't remember the exact source. I had to write it down. So there's my question to you.
I remember the idea.
Okay, but it wasn't the case of the pit. Now, Kevin, was in the case of a pit when we learned about depreciation of carcass, talking about a tam or a muad?
Tam or muad? I have a guess.
No, don't have a guess. I want to ask you something. Let me ask you. No, you do. Let me ask you a simple question. This will help you. Trust me, this will help you. When we learned the case of a pit, we said that only Keren and its Tordot have a case, both Keren being the Av and the Tordot being pushing, biting, kicking, squatting, etc. That's the Tordot, has a case of Tam and Muad. Keren only. But when we talk about Shane, Regel, Pit, and Fire, and Marve, by the way, and Marve, depending if you hold by Rav or Shmuel, Marve, in that case, it's all Muad. Remember, we said that the opening mission, according to Shmuel, Rav Yeshua Shmuel, is that it didn't mention the case of Keren, because Keren we learn about Tam and Muad. But all the other damages are Muad from the outset. So when we learned about the case of Pit, was it Muad or Tam?
No, the Pit's Muad then.
Yes. Yeah. Good one. Exactly, Kevin.
Because Pit is not Keren.
Exactly.
It's just,
Muad. It's Muad. That's exactly the answer.
It's,
No, but that's the answer, Kevin. You hit it. Is that a pit is Muad. So we didn't, so when the Gemara says, listen, we learned this before, 10b1. What's the case here? I mean, we're learning nothing new about depreciation of the ox. You're saying, no, we are learning more, because that's in a case where it's Muad. We didn't know what to do in a case of Tam, because we could have thought the following. We could have thought, listen here, this was a time ox. It's the first time it did it. And there's two ways to think of it like this. Okay, let's put it like this. So we could have said, in the case of Muad, this ox, this animal, let me put it to you in a simple way. All right. In any case of Muad, it's a hazard that's very dangerous and that you've been warned about, and it's common behavior and you know better. Let's take a case of Regel. An animal will always damage when it walks. Always. The nature of an animal is whatever treads on is squished. Whatever it bumps against is broken. And in that particular case, it's dangerous. You put a hazard in the public domain, it's Muad. It's dangerous it's prone to damage from inception. Shane, an animal's going to eat and gratify itself. These are default positions. Fire is dangerous. So in that case, you would say that the person's now making full payment based on that. There's no leniencies, full payment. And because they're already making full payment, they don't have to, in addition to that, pay for depreciation of the animal. It's enough that they made full restitution. So we would have thought in the case of Muad that the injured party better get their animal quickly to Beis Din, so that they don't be depreciated. But you can't ask too much of a person that's whose animal was injured in a muad situation, because they've made full payment. Does that make sense? But you could say maybe in the case of Tom, listen, the person only had to pay half damages. The least they could pay was depreciation of the animal. Does that make sense?
Yeah.
In other words, Kevin, I'm turning around and saying, in a case of muad, the person's paid you in full for any damage. So then they've paid in full, they've made restitution. You better get it to the court quickly so it doesn't rot further. But you can't expect them to pay for that. In other words, say a person hits a bakkie that you own, right? They're paying for the panel beaters and everything else. You can't then charge them for the tow to get their vehicle to the panel beater. There's certain things that you have to take the hit with. They paid for the car's restoration already. They paid. So in this case, we're saying they've made full payment with muad. So then you can't say to them, on top of it, you need to pay for the depreciation of the carcass. So we said we could have rationaled that in the case of the pit, because you paid muad, the owner paid, and therefore he's done his obligation, and therefore the depreciation is on the injured party. But we might not have come to this conclusion for Tom, because Kevin, you might turn around to me and say, listen, Damon, you've only paid me for half. I actually lost the full value of my ox here, funny enough. And you might, the court might say it's a penalty because your ox was tame, but I've still taken the hit for half. I don't care what the reality is that it was a tame ox. I'm still having to lose half the money. So you know what? You can pay for the depreciation. Does that make sense? So in that particular case, we have to come to learn that a tam, you still, the injured party then still has to contribute to the payment, even though that the damager didn't pay in full. And in that case, the cost for the depreciation of the carcass, even in a tam, is for the injured party. Does that make sense, guys?
Yeah. Okay. So can I just ask a question?
Sure.
I mean, why, if someone's paid in full and they're getting the full value of the animal, why is there even an issue of depreciation as extra compensation?
I'll tell you why now.
I mean, why? I mean,
I'll tell you why. I'll tell you why. Let's take an example of, let me just take a practical example today. You've got a vehicle on the road, a commercial truck, and somebody smashes your truck, and the insurance company pays for the truck to be restored back to its previous date. But you ended up paying 3,000 Rand to have the tow truck because you were stuck it was traveling to Durban on the way to Warden.
Yeah.
Now, being stuck in Warden, it's a one-horse town. You wouldn't want to die there.
Yeah.
So it got towed, the vehicle got towed, and there's storage fees now that you have to pay 3 grand, and the insurance company is not going to recompensate you back, so you're still irritated.
They would pay for this, but they would pay they would pay everything related to the damage, the towing, the car damage. That's what they would do in reality.
No. So they would pay for the car damage, but they don't pay. They do have exclusion clauses depending on which insurance company you're with. I don't want to get sued by Auto in General. I'm not with Auto in General, but there is a case where, for example, they never paid for. My friend had to get it out of the road as a hazard, and apparently he didn't. They had to send some sort of authorized tow truck to remove it. In the meantime, it was caused.
Whoopsie, you're gone.
Another panel beater, to a storage unit just in the interim and make sure it got back to an approved panel beater. Now, they were prepared to pay for an approved panel beater that was on their books. The only panel beater that was in Warden wasn't on the insurance company's books. So they said that this was for your cost. Now, he was still upset because he had to pay that out of his own pocket. So too with the muad, the guy said, yes, you compensated me from the animal, but there's all this loss that I've had of the depreciation of the carcass actually would never have occurred had your animal not killed my animal. I've still sustained a loss here. Yes, you've paid back for the animal, but the point of it is, what did we learn with the put? That you pay back the difference between what the animal is worth and the live animal. So if the animal was worth 300 zuz alive and dead it was only worth 250, you would take, and the other person's ox was worth, so it was a muad ox, you'd pay the balance of the 50 zuz in cash. But who would have to sell the carcass and get involved with it was the injured party. So the injured party now is being schlepped with having to deal with the smelly, rotting carcass. He'd have to sell it. He'd have to schlep it to court. And at the end of the day, he might feel emotional aggravation because any depreciation of the carcass, he would have to pay, number one. And the sort of schlep work in the time would never have been caused had there not been a hazard in the middle of the road with a pit. So does that make sense? Even when you win a court case and there's party and party costs, you never get recompensated for the emotional trauma, the aggravation, the time loss, and everything else. And all I'm saying is this case with my friends Bucky and Warden, okay, that because there wasn't an authorized insurance company there, according to Auto and General's policy that they deemed to be one of their selected few, they weren't prepared to the costs of the transportation with the tow truck, because it was a non-approved tow truck, as well as storage to get it back to Johannesburg in the interim, which he had to suck up. So in other words, so we would have thought, okay, so the case of it is it's Muad, he's making financial restitution, that's fine. So you'd say, okay, he's paid enough. He's made financial restitution. Let's not get petty. So the depreciation of the carcass now is for the injured party. But in a case where the animal was tam, you wouldn't know this automatically because you say, listen, give me a break. The guy's paying half the money. He's already not paying the full money. Why must I now pay for the depreciation of the carcass? Does that make sense? So we needed a rule to say that even for time you pay, the injured party pays for depreciation of the carcass. Because even though Rav Huna, the son of Rav Yeshua, said it's a penalty and the injured party isn't entitled to it. In other words, that penalty could have even gone to the court to teach the damager a lesson. And it's a windfall that it went to the injured party. The injured party still has lost out, by the way. Why? Because he's getting half the money back on his damage. Now you want him to pay for the depreciation of the carcass. He's not going to be a happy fellow. He's definitely not going to be a happy fellow at all. So on this particular basis, we're having we're saying that we needed a case to know that had we learned, for example, that on time you pay for the depreciation of the carcass, you'd need to know from what. Let's play it the other way around. So we'd say, Tom, it's really a tame animal. And because the guy pays half a penalty, half the damage. If it's compensation, it was a tame ox. If you see it as a penalty, the fact of it is the injured party got it. The court could have ended up getting that half a payment as a penalty to teach. Like, because, example, the state of New York, if you littered, the government would get the money for the littering penalty. In this case, the injured party said at least he got half. He wasn't entitled to half because the animal of the damager was actually a tame animal. So you should be grateful the court never kept it themselves. And he did get half. But you would have said that maybe because it's a tame animal, we would have said that in that case, the depreciation of the carcass is for the injured party because it was a first-time offense, or let's just say not the first 3 times, and it was relatively a tame animal. Maybe over a period of 10 years, the ox had 1 or 2 odd incidents. Even cats scratch furniture a couple of times in its lifetime. So he's saying the animal's tame. Therefore, it's the injured party could suffer the depreciation of the carcass because it's not his fault. It was a tame animal, and it was a penalty, and at least the guy got half. But with the muad ox, you could turn around and say, listen, the owner of the ox was warned that this is a dangerous animal. It was dangerous. And this animal created havoc after being warned as being habitually agora. Now, when it injured and killed this person's ox, yes, you paid for damages, but why should the injured party, you would have thought, had to pay for depreciation of the carcass? Because this was not a tame animal. Why should he take the hit? Why should he take any loss at all, even the depreciation of the carcass? So if you learned the law of Tam first, you could say maybe in the case of Muad, because this animal had been a habitual gora and the owner was warned, you might have thought that as an added payment penalty, just like you'd pay a kofar in the case of a person, you would pay the depreciation of the carcass for one that kills an animal, because this ox was dangerous and the guy should have known better than to keep the ox. So whether we needed both these rules to show the rationale and logic that whether it was a tam animal or whether it was a muad animal, the depreciation of the carcass is for the injured party, always. And we now understand this better. I hope this has been of some help to you guys.
Okay, so I've got a question. Sorry, I need some clarity. Okay, I understand the Tam part 100%, so just leave that out. I'm going back to the Muad part, okay? Let's talk about the pit. So an animal falls in, it's Muad by default, okay? Animal falls in. All right, isn't the depreciation then the damager loses out? Not the damaged party, as far as because isn't he paying the difference between the value of what the animal is and what the value of the animal was alive?
But that's exactly the point. That's exactly the point, Gavin. So you answered it in your question. So again, I'm just going to go from memory here on 10b1.
Give me clarity. Okay? Even if I answered it, I'm not understanding it 100%. So just give me clarity.
Okay, but give me a chance to answer it. So this is the case, is that the damager that created the hazard of the pit owner, let's call him the pit owner, okay? An ox fell in and died, okay? And that ox is worth 200 zuz. Okay, let's take an amount of 200 zuz. When the carcass is only worth 150 zuz. So the animal while alive was worth 200 zuz. The animal dead is worth 150 zuz. Okay, so the 150 zuz is what the animal is worth dead. The pit owner only has to make the restoration, just let me finish please, of the 50 zuz. But the depreciation of the carcass is for the injured party, meaning that the value of the ox at the time, now this is your question, it's going to get a bit more complicated, and I'll tell you why your question's a good one, is that we work at always what the value is at the animal when it first died, not the decaying animal. So if the animal when it first died was worth 50 zuz, just let me finish, please.
I've got
50 zuz less, so it's worth 250 zuz, that you would think that you pay the owner because it's muad, it said, and it uses the term, and the carcass shall be his, meaning the injured party has to now go to the cost of pulling out the carcass out the pit and the depreciation of the carcass. But we know that the carcass is only worth 250, so he takes the carcass back, and the guy only has to give him 50 zuz cash to replace the difference between the dead animal and the living animal. He only pays the difference, but he pays the difference pre-depreciation of carcass, while the animal dies immediately. Where your question is a good question is we're saying, but hang on, if there is depreciation of the carcass, by the time he gets to court, how do we know what it's appraised at when the animal first dies? Yeah, now that's a question.
Because we said yesterday they were short-staffed, you know. which is correct. They wouldn't
Yes,
have
so
how would they
the
have
question.
been able to do the value on that day?
Okay, so that's the actual question that I want to know in more detail. How did they know the value on that day? In other words, if we want to say there's depreciation of the carcass and you need time to schlep it out the pit, and if you can get it, in other words, if you can get it out that pit immediately enough to assess what it is immediately upon death, okay, then in that particular case, you know what the animal is worth, and then why would you need to lose time to take it to court? Or if you need time to take it to court, how would you know what it would be before the animal started to rot? And you can assess it at whatever point you took it to court with the rotting animal, or to the degree at which it rot or depreciated.
Yeah.
So the one thing I thought,
the best value is when you actually sell it. They should sell it immediately. That's my opinion.
alive and dead, had a certain value. The value was that an animal was a working horse. It was an animal that provided usefulness and therefore had a saleable value upon which you purchased it. And then it has a different value for the meat. Does that make sense? So the thing of that is, there's a difference between what you would weigh it at when you pulled it out of the pit, and by the time, which you could weigh it relatively easily in order to make restitution, and by the time your case was heard. So they must have had a mechanism in terms of how to weigh it and the delaying sort of portion. But I would like to speak to Rabbi Cohen in terms of how that actually worked in practical terms.
Yeah,
Even though we know the theory.
I'm also quite because I've got the theory now as well. Thank you. You explained it well. But practically,
And
quite interesting. They must have had a technique where it couldn't have been too long, because if you left the meat for 5 days, it would rot entirely, you know. So they must have had some sort of mechanism to do it quite quickly.
Yeah, but listen, it must have been long enough to appreciate in some sort of value.
Even a day.
This
Even a
discussion would
day.
never take place.
Correct. But even a day sitting rotting is going to depreciate that meat, you know.
Yeah. So guys, thank you very much for the share.